Today, we're going to talk about presumptions. We're going to talk about our friend accepted and denied cases. I'm going to breeze through that because I know this group knows that stuff already. I'm going to talk a little bit about occupational disease cases. There's like 3 cases I'm going to cite and talk about. We're going to talk about our friend average weekly wage because that drives exposure in our cases, so I have to talk about it. And what I really want to talk about, and because we have clients attending this and carriers and employers, I want to talk about what could we do better at the case foundation level, at the beginning, to put ourselves in better positions in the case. So we know we're in this indifferent, often hostile court system. We know we have opposing counsel. We know the claimant gets all the presumptions. We know the judge is often not acting impartially. They're acting almost like they're the claimant's counsel as well, right? So the deck is stacked against us. So when I thought about this presentation, I thought, like, how can we help our clients stack the deck in our favor, right? How can we tilt the game so that we're in a better position? So when we think about the beginning of a case, what can we do? What could our clients be doing better? What can they be providing us in terms of information to tilt the board, to give us an unfair advantage? Because that's what we're here to do, right? We're here to create opportunity for our clients and give them an unfair advantage in court. That's what we're here to do. That's our job. What's our mission, vision, and values? Since it's the first one of the year, I'm going to remind everyone my job is to build a great practice for our clients. That means we're competently defending them, appropriately defending them, and I want to provide every single person in this room and that's listening with a great life. That means you deserve to work in a place that's well run, that has clear expectations, that has got clear boundaries, that compensates you well, that takes care of your health and wellness, make sure you have the insurance and benefits you need. But most of your good life is going to be outside of these 4 walls, and I want you to have as much time with your family and friends and loved ones as you possibly can. And that's our vision. That's what we're here to do. Our mission day to day is to take control of these uncontrollable cases. And this morning, I want to talk a little bit, this afternoon, I want to talk a little bit about how we do that. You know, so many times we're saddled with these cases. We cannot choose the cases that we're defending, right? We are not in charge of workplace safety. We're not helping employers screen their employees. We can't make the employees act in a safe manner, right? They're going to do like crazy, ridiculous things. I got an email last night from my client and they said, is this a compensable case? Actually, this is a good one for the group. You ready? Employee leaves work, goes out to his car, and he wants to warm his car up because it's cold, right? It's cold here this week. And he goes out to his car and he leans into the car. He puts his foot on the brake pedal, starts the car. Somehow the car slipped into gear and dragged him through the parking lot. Okay, now he was doing something personal, right? He was trying to warm his car up and got halfway in the car, got his foot in there, and then got dragged by the car. Compensable or not compensable? What's the question we need to know the answer to in that situation? Yeah. Right, is it on the premises or not? And they said, yeah, we own and control the premises. They said, I'm sorry, you got a workers' comp case, right? And you think about that, like, what could the employer have done better to avoid that suit or that claim against them? Like, nothing. Like, that's a silly-hearted thing that person was doing, half in and half out of the car while it's in gear. So our mission, unfortunately, or our challenge sometimes is we're dealing with a set of facts, a situation that we didn't create, we can't control it, and we always say, you know, intake doesn't, like, can't say, oh, well, only send us the easy cases or send us the simple ones, right? So what do we do after we get this case? And what could the employer do in these situations to help set us up? When we defend cases, we want to be creative, and I want to talk about how we're going to be creative even at the foundational level of a case. We're here to be advocates, okay? I hope you're here because you want to win. That means, what is winning for us? Winning for us means we're giving our client an opportunity, we're creating opportunity for them. Sometimes that's just creating chaos. Someone got me for Christmas this lovely pin, which is of a grenade, which I'm wearing today, because that's what sometimes all we can do. We can make chaos for the other side. We make them work a little bit. Maybe that's how we can be an advocate in our cases. The boundary on our advocacy, I mean, I want you all to be bloodthirsty barbarians out there attacking the other side's case, looking for the weak points. The boundary of that is going to be civility and professionalism. And we can never lose sight of the fact that we're here to provide a service. And we're going to ratchet up and down the level of our aggression and the level of what we're doing to match our clients' needs. So that's who we are. That's how we serve our clients. So let's start right at the beginning. Time of loss, accident happens. Some silly heart is warming up his car. And what does he do? He runs himself over in his own parking lot, right? What can we do? First question that's going to come to us, accept or deny the case. Most of the time, intake is going to be providing this initial advice to clients. But you can provide this advice as the case goes along. You go, hey, wait, this is not one to accept, this is one to deny. Whenever every case that we accept, we ultimately can change our litigation position and decide to controvert. That's nothing wrong with doing that, but we should think about this. And we should be thoughtful too about the psychosocial elements of these cases. Sometimes we'll tell a client, hey, accept the case, even when it's questionable, right? Why would I tell them to accept the case? Well, maybe you're gonna, if you accept the case and you start making sure the person's getting to treatment, you're setting up those appointments for them, you're helping them, they don't become adversarial to you. They're not gonna go lawyer up and hire the lawyer who's advertising on daytime TV or on bus stop benches, right? So maybe there's an opportunity there. Maybe they're gonna be a little more cooperative. There's no advantage in this jurisdiction to accepting a case because you're not in regards to medical, right? Whether I accept or deny a case, I have no control over medical. Are they gonna choose good doctors to go to? No, they're gonna choose these jokers that are all being sued in the tradesman case and now the American Transit case that are gonna keep them out of work forever. So it's really, I think, neutral whether you decide to accept or deny a case in terms of controlling medical. We also think our experience has been when you accept a case initially and then later on you deny it for either legal or factual grounds, we all know it's less likely that the judge is going to sustain that denial. I've had so many judges say to me things like, well, you initially accepted it, Mr. Lois. How are you controverting it now? I'm like, well, I learned more. We found things out. Our investigation revealed this didn't happen at work, right? Now, if you deny a case, the downsides are they're much more likely to seek representation. I mean, statistically, they get annoyed, they go and hire an attorney. Again, I don't know if this should drive acceptance or denial reasons. I think does everybody in this room have like another attorney in the family, right? Everybody has someone in their family that they would go to and ask these questions of. What's the number one predictor, by the way, of you're going to file a workers' comp claim? You filed one in the past. What's the second biggest predictor? Someone you know in your family has filed a workers' comp claim, right? Once you've been through the system, you're more likely to do it. So again, I don't know if it's going to have much power of dissuading people to file these claims. Again, you deny claim, you're not going to have any control over medical. You can choose to deny it and then investigate and then later accept. That's fine. You can deny without any prejudice to your ability later to accept. I've never seen a court or a judge or even opposing counsels oppose me or challenge me. I say, oh, we're going to accept this case. We did an investigation. We decided it's compensable. And the other thing to think about when we deny cases is, well, there might be a timeline that's going to work against us, right? That rocket time, which we're going to talk about in a second. All right, let's talk about the other things that are against us in this jurisdiction. This jurisdiction affords claimants 5 presumptions. And these 5 presumptions are first, that the case is compensable. Literally that first sentence in section 21, it says the claim comes within the provisions of this chapter, just means that anything filed by a claimant, presumed compensable, that's all that means. And that notice has been given, unless we raise notice as a defense, that the injury was not self-inflicted on purpose. They didn't try to harm themselves, even if they did something incredibly silly-hearted, like drive over themselves with their own car. That the injury didn't result from their own intoxication, right? And the last thing is that everything that's in the medical reports is accepted as in evidence unless we challenge it. Okay, so if it's in the medicals, it's accepted. All right, the decision point that we have when the case comes in, accept or deny it, things that we want to look at, are they losing time? Do I have to pay wage replacement? How much are we paying wage replacement? And what happens if there's no supporting medical? Well, we know in this jurisdiction, under the 1018 rule, even where there's no supporting medical, we have to pay workers' compensation. It is ridiculous unless we are controverting a case. So even where they don't have it. I have a picture up on the screen of an employee claim form. Anybody call out what percentage of cases come in with a fully filled out employee claim form? About half, maybe less than half come in with those. Less than half, James is saying, less than half. Okay. Oh, then what do we do at the very first proceeding? We should be asking for a signed employee claim form. Why? Because I can use them later on in the case to challenge body parts, challenge mechanism of injury, challenge parts of the case. So this is the beginning. So we've decided to accept or deny the case. That's our initial consideration. Roughly 85% statistically of cases are going to be accepted immediately as compensable. Remember, they get the benefit of all those presumptions. Our waiting period in New York is 7 days, which means until they lose more than 15 days, or on the 15th day, we're not going to go back in and fill in that first 7 days of lost time. I'm going to talk a little bit about maximums and minimums and how much those are changing. And of course, what happens next? Medical treatment begins. And they start treating with these Dr. Mills that are going to write them notes to get them out of work. For clients, employers, carriers that are listening, we have an intake department here that'll help you make these decisions. If you send a new matter to newfile@loisllc.com, they will guide you through the process. They'll do a quick conflict check. Even if we don't open the case, we will send you a written compensability decision. We will send you advice, usually the same day, so that you, the employer or carrier, can paper up your file. If you want us to represent you, we'll also the same day send out the letter of representation. We'll send HIPAA releases. We'll do all the things that we need to do, including protect Section 29 rights. What's been coming up recently, and I know it happened with you, Misha, it's happened with you, Declan, it's happened with me. Opposing counsel keep talking directly to our clients by going around us. Raise your hand if that frustrating situation has occurred, right? And they say bad things about us, and they go, oh, blah, blah. All right. They're not allowed to do that, okay? That's ethically wrong. They shouldn't be doing it. And it's why, by the way, at the beginning of the case, we filed the letter of representation. That's not required under the workers' compensation law. That's something we do on purpose because it triggers an ethical duty on the other party that now they know this party is represented. Opposing counsel should not be talking to our clients around us, without us, dropping us off as CCs. Attorneys should not be doing that. If they do that, please report it to me or Declan. Now, we've been very kind about trying not to file ethics and grievances against other attorneys for doing this, but my position has changed in 2025. We're going to file away, okay? And there are some law firms out there, Savino, Smaller, Jason Smaller. These are bad actors. They are doing bad things, and we are going to file ethics complaints against them, all right? So if you see that happening, let us know. That is something for me and Declan to do. It'll go out under my signature, not yours. But I got to complain about them, right? I have a duty as an officer of the court to do that. So clients, if you're out there and you have a question about should the case be accepted or denied, we will help you. The thing I want clients and us to be mindful is, of course, in a denied case, the timeline works against us. We are no longer in control of the pace or tempo of this case, and that never helps us to be under the timing gun. What happens next? We make that compensability decision. We say we're going to deny it. We tell the client what codes to add to their 404. What else do? We file a pre-hearing conference statement. The court is going to set the case for a pre-hearing conference. We're going to start having to put together our proofs, and this is like a hurry-up offense. We're going to have to be moving pretty quickly to make sure that we secure enough information, evidence, witness statements, affidavits, whatever's. We're behind the gun. These are the cases that we need to rush on, okay? The parts of a denial that are required are the 404 or 404 that cannot be filed by us, that has to be filed by the carrier or TPA. We will file a pre-hearing conference statement, and then paraprofessionals, as the case develops, we're going to amend that pre-hearing conference statement. Okay, that is everything that's included in there. That's what we're allowed to bring into the proceeding. If you read the regulation, section 300.38, if it's not on the pre-hearing conference statement, technically the judge is allowed to preclude any witness, evidence, document, piece of information, videotape, investigator. That's why we file these pre-hearing conference statements with these big, broad, vague statements like anyone in the world with any knowledge of the accident, right? That's to protect you so that later on in the case, when you try to bring forward a witness, an opposing counsel, if they're savvy enough and have actually read the regulation, raise your hand if you've read regulation 300.38. Okay, good. Oh, yeah. For those at home, everyone just raised their hand. They are very aware of it. I don't know if opposing counsel will read it or not, but if they did, they would be able to preclude anything that's not specifically enumerated in that pre-hearing conference statement. So let's be thoughtful about it. Now, denied cases go on to this horrifying, awful, expedited hearing calendar, also called the rocket docket. All denied cases get a pre-hearing conference as long as there's one piece of corroborating medical. Although in my experience, sometimes they don't even have any medical. It's just the C3 alone that's going to get them, and our denial, that's going to get it to a pre-hearing conference position. Also last April, the board began indexing every case in which there was a fraud. So now we're seeing even more of them come out. Statistically, the board releases statistics every year in their state of the board. And this is the one thing the board's actually pretty quick about doing. They are very consistently setting that pre-hearing conference generally within 30 days of us filing the pre-hearing conference statement. So that's the timeline it's kicking. From the date of the pre-hearing conference, by law, the decision in the case all the proofs have to be in, and the case has got to be before the judge, ready to go, depositions done, within 60 days. That's not good for us, right? That's a very short period of time to have to get depositions done, maybe get an IME, get an impartial, do all the things that we have to do. So let's put on our thinking caps and be creative. Let's get this thing off the rocket docket. What are two automatics that get you off the rocket docket? Does anybody know? Automatic. Occupational disease cases, right? So think about your respiratories, your cumulative repetitives, your hearing loss cases, your inhalation cases, okay? Automatic. What's the other one? Go ahead, Mr. Gurley in the back. I'll give it to T in this. Go, yeah. Complex claims. Now, what the F is a complex claim in workers' compensation? I don't know. I don't know if there's case law on it. But if you think the case is weird, there's maybe a complex etiology or there's a lot going on in the case, let's claim that it's a complex case and try to get it off that rocket docket, okay? Deaths are also excluded from the rocket docket as well, okay? So again, those rules are section 300.38. Review them, right? Because that's really going to be the foundation. Those are the first arguments we want to make in court. And remember, opposing counsel has to file a pre-hearing conference statement as well. Do you see them often? And are they filled out completely? Absolutely not. Now, here's an interesting moment. If we fail to file a pre-hearing conference statement, what happens to us? Our defenses are waived, right? The judge can find the case against us. We have to file that pre-hearing conference statement 10 days before the pre-hearing conference, or we waive those defenses. What happens to the claimant under section 300.38 if they fail to file their pre-hearing conference statement or it's incomplete? Does anybody know? The attorney doesn't get a fee. Okay, now I love to raise this. Does the judge ever withhold their fee? No, but it gets them annoyed, and maybe it's like, hey, let's talk about section 32. Let's get some leverage or get some momentum in our case. So that's something that we could bring up. Now, some deadlines for clients. Once the case is indexed, and the board is indexing more cases than ever, they have an initiative to index as many cases as they possibly can because they got in trouble for not doing that. Our client has only 25 days to file that Freud-04 denial type. Now, penalties for failing to file that, of course, are waiver of defenses. It seems insane to me that if you fail to file a piece of paper, that you're going to waive potentially jurisdictional cases or jurisdictional defenses, but that's what this jurisdiction says. All right, what's the second thing we're doing in a denied case? The second thing, you're now a LOIS lawyer, you're getting a case assigned to you, you know it's a denied case. Well, I think we need to think about what is the reason for the denial and what are the proofs that we have to assemble and put together for us to prevail in that denial. And prevailing in denial, in my mind, is merely keeping the case in denied status, getting that denial sustained. So it means that for the very few disputes that reach this stage, lack of coverage, lack of employment, no accident, those types of cases, it's knowing the elements of the case that the opposing party has got to show so that we are prepared with contradictory proofs or that we can attack their proofs. All right, COVID claims. This slide's still in here because people used to care about COVID. Obviously, we don't care about them anymore. I used to think COVID cases were going to be this massive bubble. At our peak, I think we defended like 50 or 60 of them at a time. It would never really turn out to be much for us. The board did create its own new standard, which was prevalence. And They said this is 3 years ago. They said, well, if it's prevalent in the workplace, someone catches the COVIDs, well, then we're going to find that to be compensable. And they just made the standard up, right? Because if they applied the actual correct legal standard for an occupational infectious disease, none of the COVID cases would be compensable. We challenged it. We took it up to the appellate division, and we lost. Okay, the appellate division is like, yeah, I don't know. It's an emergency. They can do weird things, and they did. But here's what's more interesting now, and this is why I don't think we're going to see COVID cases anymore. Once they declare COVID pandemic, right, they say it's everywhere, then it's not prevalent in any one workplace, it's prevalent everywhere. So that's why these are kind of non-starters anymore. All right, occupational exposure cases, occupational disease cases. This is an interesting subclass of cases. When the statute was first written back in 1913, they listed out every possible occupational exposure injury that you could have. All right, now think back to 1913. It's like the land before time, right? I mean, cars were like just being invented, right? I mean, this is like a long time ago. And if you read the original statute, it says things like silicosis, asbestosis, all sorts of dust diseases. And they literally list them up, coal miners' lung. They listed all these things. They said, well, these are the things that you could possibly get in the workplace. And there was a limited list when they first started the statute. In the 70s, they updated the statute and they changed Section 3, and now it just says any and all occupational diseases could be an occupational disease. In other words, anything, okay? There is no limit on what a claimant can allege was occupationally created. So male pattern baldness, chronic halitosis or bad breath, all of those things could be legitimate occupational diseases under our current statutory definition. So the answer is literally anything. The most common ones that we're going to see, hearing loss cases, right? Sensorineural loss, that is compensable, not bone conduction loss. Be very careful when you're looking at those hearing claims, right? I'm an old person, I'm getting a little hard of hearing. Why? You get older, your bones shrink, and if you can imagine this, I am going to get even shorter as I age, I presume. And the bones in your ear shrink too, and that's why grandpa is like, what? What did you say? Okay, it's natural. The only type of hearing loss that's compensable is sensorineural hearing loss, which means it should be in specific frequencies, okay, specific frequencies. When you see a hearing test and every frequency is lower, and they go, look, there's a 20% binaural hearing loss here. Could that possibly be compensable? There's not, that's just aging loss, okay, so those are not compensable. But sensorineural loss in narrow bands is compensable. Respiratory injuries, inhalation injuries, right? I've been breathing in lead paint fumes. I once defended an employer that we had a physical plant right here in Fairlawn, and we were processing photographic film. And guess what? Everybody who worked in this plant, over time, everybody developed a very specific form of bladder cancer because of the chemicals that they were exposed to, right? And over a long period of time, that did accumulate in their system and cause this very specific bladder cancer. Orthopedic injuries, repetitive use. Now, there was a lot of claims for carpal tunnel, cubital tunnel syndrome. A lot of our clients just accept these cases because they're so treatable and they are so easily remedied with relatively minor surgery. But really, these are probably more related to age and sex than they are to anything else. In the general population, the #1 predictor of carpal tunnel syndrome is postpartum female over the age of 50, period. There's something in hormones that are from having a pregnancy that are predispose you to having carpal tunnel syndrome. So in the general population, you find it all over the place. One of my good friends, Arthur Canario, his wife passed away recently, but she was a concert pianist. And he used to say to me, he's an orthopedic surgeon, he used to say to me, Greg, if you got carpal tunnel syndrome from typing away at a computer for 40 hours a week, don't you think every concert pianist by the time they were 30 would have carpal tunnel syndrome and cubital tunnel? And of course they don't, right? Because it's just genetics predominantly. But anyway, this is one of the ones that we see all the time. All right, what are the limitations on occupational disease cases? Well, the limitations are the claimant has to demonstrate something unique, some unique or peculiar feature about the employment that exposed them to that specific condition, okay? So things like my back hurts because I stand a lot. That's never going to be compensable. That cannot be compensable in our statute. because everybody stands, right? Or my back hurts because I sit a lot. Can't be compensable. Or the neck injury guy who says, I sit at a desk and I use a computer and I developed a neck pain. Can't be compensable. There's nothing peculiar or unique about any employment that exposes them. That's why heat, cold injuries, sunburn, things like that can't possibly be compensable, because every employment theoretically could expose you to sunlight, right? Things like that. All right. The statute of limitations, unfortunately, in an occupational disease case is 2 years from the date they knew or should have known that the disease was compensable, or sorry, related to the employment. When is that date usually? The day their attorney tells them it is, right? So really hard to prevail in a statute of limitations defense in New York in an occupational disease case. But I would tell you, and the way we defend all of these cases, occupational disease cases are very fact specific. If you can go back and find a medical record where they said 10 years ago, they told the doctor, yeah, my neck hurts and it's been hurting every day because I've been doing a lot of overhead work at work. They didn't file a claim, they retire 10 years later, they say I have a neck injury. Well, you can say, wait a second, you knew about this 10 years ago, you complained about it to your doctor. That's why fact investigation is the best way to defend an occupational disease case. It is not with an IME. It is a fact investigation defense that we need to put together in those cases. All right, what kind of condition is going to be compensable? Well, there's something unique in the workplace, something peculiar. I'm looking for something out of the ordinary that caused this condition, something special. And everybody was exposed to this specific chemical. Everybody got a very specific type of bladder cancer. There's probably a very clear medical causation there. And the risks cannot be shared with the general population. So when you get these end of career cases, right? The construction worker who files the occupational everything case, they go, I did all this overhead work and I walked up and down ladders, and then, so what? So does everybody else. There's nothing unique that they can point to. Those are Section 32 cases, nuisance value cases, all day long, okay? They have to be also brought timely, but again, the statute of limitations defense is almost impossible. Not likely to be found compensable are those cases where they can't say there's some specific inciting, instigating factor that's peculiar to the workplace. And I want you to keep thinking of the word peculiar, because they should be. All right, date of disablement. Here's another fun one. When do benefits begin, or when does our exposure begin, or when do we go back in time and start compensating them from? When were they actually disabled? This is like one of those academic ha-ha cases or situations, because Section 42 says it could be anything. It could be when the last time they were exposed in the workplace. So that's typically what you'll see in a retirement type case. You know, the over-the-road truck driver who drove for 30 years, then retired, then brought their occupational everything case. That's what we would typically see them saying, well, when were you exposed to all this vibration that caused these pain in your back? I guess the last day I worked, right? That's one. They could also establish it at the date they first got medical care for it, the date they had knowledge of the specific injury, or the first time they missed days from work. Although in cumulative traumatic or cumulative orthopedic cases, I almost never see a day lost from work. It seems to be post-employment claims. All right, how do we defend these? Well, I guess I already gave this away. The focus should be on the facts. This is the moment where you do a deep dive. These are the ones where you want to put the effort in. The right answer in an occupational disease case is not an IME. What's an IME going to tell you? Nothing, unless you provide them with lots of great information that's going to help them. Now, we have limited discovery devices in this jurisdiction, right? Guys, do we get to serve interrogatories on opposing counsel or a bill of particulars and make them swear to all the things they were exposed to? No, we get stuck with whatever they say when they're testifying and whatever they've told their doctors. So we've got to develop this from our client. This is where clients need to be hopefully cooperative with us and give us information about the location or the work that they were exposed to. And particularly in an exposure case, again, I think these are very defensible cases with like a little bit of legwork. My experience, particularly with the post-employment ones, right? I've defended occupational cancers, occupational deaths, asbestosis cases, inhalation cases, the nasty ones, the ones where there's going to be a big exposure, but the employment's been shuttered for a decade, right? The business has been closed maybe. They worked in a plant, and now they're claiming they were exposed to asbestos or they were exposed to specific chemicals, and that caused their chronic rhinitis and their chronic bronchitis or whatever their claim is for. How are we going to prove this where the plant's been closed for 10 years, maybe demolished, the records are gone, right? What are we going to do? My advice is, hey, OSH keeps records forever. Environmental testing records have to be kept forever. Even where employers close locations, they sometimes will keep their industrial hygiene surveys or the hygienist reports that they have for those locations. We could try to find people that work there that can testify about what the workplace was like, what were the ergonomics. Again, this is the moments to dig in, particularly in the higher exposure ones. Is it right in your rinky-dink, I worked in a plant, I carried some boxes around, I have a back case, and it's going to go for very small section 32 value? Probably not. But put on your judgment cap here and go, wait a second, the leukemia cases, the chronic bronchitis cases, anything respiratory, right? Because the person's ultimately going to die at some time. And what's it going to say on their death certificate? What is the number one cause of death, no matter from all cause mortality? It always says cardiopulmonary arrest, or it'll say respiratory arrest. It means you stop breathing. So then you're going to have a death case later after you have an established occupational respiratory case, because they're ultimately going to die, and they're going to come in with this their Section 62 affidavit and say, look, now we have a death case. So defend these, challenge the dates, use OSHA records, use awards. I defended when you're driving down the turnpike here in New Jersey between exits 12 and 13. Now it smells bad because we have the Linden cogeneration plant there that makes the gasoline refinery that you pass on the turnpike. We've all seen that thing. I defended that place for a long time. That facility wins these awards every year for the cleanest air of any facility that processes gas. I know it sounds crazy. You're like, what? Somebody gives awards out? But yeah, they do. They rate them. And so when someone brings out a respiratory claim, they go, hey, it's a terrible exposures to these chemicals. So well, no, not really. Actually, the atmosphere inside the plant is actually cleaner than in the town of Linden that's next door to it. Okay, I know it's crazy, but like you can defend these cases. It's got to be a little bit creative. All right, so what's our considerations when we have one of these cases? First of all, an occupational case, exposure case, should always be off the rocket docket, okay? Because it's complex, all right? They're claiming, even a hearing loss case, get it off the rocket docket. You're denying these cases, make sure they're not on that docket. The timeline's gonna work against you. You're gonna need to do some discovery, particularly in that higher exposure case. We should also be thinking about apportionment in these cases. Like, who else contributed to this person's condition, right? So there should be a lot of time and effort and blood and treasure put into that. Apportionment to joint employers. We're always looking, I love successive employment, particularly if I can find there's somebody else later on the risk, later that employed them doing anything. I'll be like, well, look, this condition didn't manifest during my period of employment. This condition manifested, became fixed, measurable, and arrested during their employment or after it. So I'm going to be pointing those fingers. There's plenty of case law on apportionment, particularly in the occupational successive exposure case. So you should be able to get contribution from someone else. And that is our goal, to try to have someone else jump in. All right, let's go through average weekly wage really quickly. I know this doesn't seem like an exciting topic to anyone, but I think we should focus on it. Yesterday, so I was in office hours, and someone brought me this case, and this is not an apocryphal story. This is a real story. Back me up, right? Attorney's in my office. She goes, "This is a terrible case, Greg. Bilateral hip replacements. We had and a 3-level fusion, cervical fusion. All right. So what are we all thinking here in this room? Say it out loud." Bilateral hip replacements, 3-level cervical fusion. It's a total case, right, guys? I mean, that's a total case. Let's go for total. Don't we think so? Hello, are we here? Come on, please at least nod. You're a live audience. Please make this interactive for me. Total case. And she was worried about it. She's like, what are we going to do? How do I defend this case? I got bilateral hip replacement. I'm like, yeah, this is real. The average weekly wage was $312 a week. Are we worried about a total case now when the average weekly wage is $312 a week? Not so much, right? Because the exposure is not going to be that bad. So I think average weekly wage, from our perspective, yes, it's important because it can help us reduce exposure, right? But also it helps us in our workday prioritize our cases. Now, they said to me, oh, this person, bilateral hip replacements, 3-level neck fusion, oh, and the claimant made $2,100 a week, I'd be like, oh crap, we're in trouble here. We got to try to avoid total, or we've got to try to bring in another party, or we've got to run. We got to do something, right? But when you tell me, okay, the average weekly wage is very low, I'm a little bit less stressed out about this case. So I'm saying, well, the total potential exposure is not that great, right? So it should help you prioritize your day. And I'm saying, by the way, just to be very clear and to help out Declan, I'm not saying only work on cases where the average weekly wage is over $2,000 a week. I'm not saying that out loud. I'm just saying it can help you prioritize yourself. Temp rates are 2/3 of the average weekly wage, subject to a maximum and minimum. Okay, we all know that stuff. How do we figure this out? Wage statement is foundational. We should be getting these from our clients. This is key. Please, let's not defend any cases that do not have a valid C-240 in the case. What's great wage information? The C-240, obviously, I love it. Anything I'm getting from the employer, payroll records, their Paylocity account or their ADP or whatever, that's fine to me. What if we don't have any of that stuff? Give me a similar worker, okay? We try to play the game of, let's find a similar worker who has the same job title, but who's in Arkansas. It probably makes peanuts compared literally to what our New York worker is. No, let's try to find a legit similar worker, roughly the same age, hopefully the exact same job title, doing the same work for the same employer. That's fair. I mean, we're not trying to game this. Social Security earnings statements. Okay, in our system, Practice Master, there's a workflow that will prepare and get you a SSA Form 7050. Every time you've ever worked for any employer, even before you were 18 years old, that employer had to report your wages to the federal government. So there are these wage records out there that we can obtain that are pretty valid because it's the employer reporting them, okay? This becomes incredibly important in occupational exposure cases where the person worked for us 20 years ago, 15 years ago, and says, now I've got leukemia because I worked in your plan and I was exposed to XYZ. We probably don't have those records anymore. The company might not even be in business. Social Security still has those records and you can obtain them, okay? There's a form you can file. It's straight ahead. Bad sources of information. Anything turned in by opposing counsel is probably fraudulent. Don't trust it. Okay, this year, no, not this, 2024, we literally had cases in which claimants came up with, you had fake checks that they barely did a really bad job of falsifying those checks, right? It was your case, right, Karen? Yeah, I mean, we see this stuff. Anything they're gonna hand in, I don't believe it. Now, the bigger challenge is these off the books or undocumented employees who are getting paid wages under the table or whatever you want to call it. That's a challenge, right? We're going to have to talk about that with the employer, but anything they turn in. Cash tips don't count. It's really cute that, you work as a valet and you're parking cars and you say you get an extra $400 a week in tips. If you're not declaring it on your taxes, we're not counting it as income. That's the rules, sorry. Worst source, tax return. Tax return is the worst source. So a claimant who comes forward, it says, look at my tax return, I made $1 million last year. It's like, who cares? Anybody could write anything they want on a tax return. Believe me, if I wrote on the federal government, I made $2 million last year, they'd be happy to see that on my tax return. It means they could tax me more, right? Nobody's checking that. That's a self-created document. Don't believe tax returns. And you have up to 3 years to go back and change your tax returns if you made a mistake. So you could file one right now saying you make X amount of dollars and go back 3 years later, change it. That's not something valid. Let's not use that. All right. Whew. Gotta get my breath here. I love average weekly wage. Can you guys tell? This is exciting. This is fun stuff. This is great. All right. How do we calculate it? Well, there's different ways to calculate average weekly wage. The way I like is called straight division. We just take up all their wages and we divide it by the amount of time they worked for us. I think that's fair. I'm not here to game wages, by the way. I want us to be just fair. So let's just be as fair as we possibly can. But when you look at these wage statements, you realize there's missing weeks, or they took days off, or they only worked 3 days some weeks and 5 days other weeks. It gets all confusing. And to make it even more confusing, the legislature gave us a strange statute that says we make up hypothetical wages for people using daily multiples, right? Nowhere else in life do we make up fake wages and use daily multiples, but the Workers' Compensation Board loves this idea and they've adopted it, so it's terrible. Another thing we could do is a similar workers' wage statement where we have incomplete wage information. Now, when you calculate this stuff up, you're going to come up with wildly different numbers depending on what method you use, even if we're not trying to game the system at all. My experience has been straight division makes a lot of sense, particularly when we have full weeks, and particularly where they had variable earnings in weeks. I'll just say, hey, you worked for us for 47 weeks, you made $37,000. I'm going to divide up the amount of money you made by the number of weeks, and there's your average weekly wage. That's the method I stand by. Now, I know that I tell you and instruct you to do this, and you go to court and judges say, oh, no, we're not doing that. We're going to use the hypothetical weeks. We're going to make up a wage using a 260 multiple. The way this works is you essentially come up with an average daily wage, and then you multiply it by a hypothetical year that doesn't exist, right? Nobody actually works 260 days a year. Think about it. There's 365 days in a year. That means there's 104 Saturdays and Sundays. So right off the bat, you're down to 256. Plus, you're going to take vacation days, sick days, time off, right? I mean, everybody does, right? 10 holidays if you work at LOIS LLC. No one works 260 days in a year, but the board came up with that as a hypothetical year. And I promise you, every time you use a 260 multiple, you are always mathematically going to come up with a higher average weekly wage. That's why claimants love it. That's why judges allow them to do it. And it's in the statute, so it's really hard to fight, okay? But fight it. Make the fight, all right? And remember, the argument here is just fairness. Okay, it's not gaming. It's not trying to come up with the highest average weekly wage. And I'm not arguing for the lowest. I'm just saying let's look for the fairest. I want us to be the voice of reason. And the last choice, of course, is similar worker. That's where we use someone else who has the exact same job title. I would like them to be in the job about the same time as the injured worker. I would like them to be over the age of 25 or about the same age as the injured worker. If you do these three methods, use the same exact person, I promise you, you will come up with three wildly varying numbers for what the person's average weekly wage is. Again, the other side is going to try to argue for the higher average weekly wage. Nothing drives me crazier than as these cases progress over the years, somehow the average weekly wage keeps going up because they keep figuring out, they're finding more information about how much more money they made. Concurrent wages should also be added together, but again, only for permanency, right? So they have concurrent wages. We're adding that together for the determining permanent residual disability benefits, not for temp. I'm sorry, that's minors, not concurrents. Minors are entitled to a made-up fake average weekly wage, right? Because we're going to try to be, we're going to presume that if they had continued in that career past the age of 25, they would have earned more money. But we only reconstruct a fake wage for minors for permanency, not for temp. All right. There's a maximum and minimum. It changes every year. Guess what? It's going to go up every year. Why? Because the state average weekly wage, the way it's calculated by the Workers' Compensation Board, by the Department of Labor, is skewed so it always goes up. It's interesting that the state average weekly wage excludes all sorts of employments, and it excludes state employments as well. So it is almost guaranteed to every year go up and increase. And this is important for us because when you think about your clients and they have to report to their boss. And every year their boss is going to be like, how come our workers' compensation losses are higher than they were last year? Well, even if we did a great job, we did a perfect job, we didn't do anything that increased their risk and we kept their exposures at the same level. Just the fact that the benefit rates are going up every year makes them look worse to their boss. And 2 years ago, the board, the legislature, I should say, passed a new law that says the minimum benefit is now going to be pegged to the state average weekly wage. Okay, so this is following about 40 other states that peg the minimum rate to the state average weekly wage. New Jersey, for example, does this. Last year, the minimum rate was $275 a week. Now it's $325 a week for new accidents after January 1st, 2025. Starting next year, I don't know what it's going to be, but it's going to be 1/5 of the state average weekly wage. And if we use the last date that was calculated by the board, it means the minimum rate would increase to about $350 a week. And it's just going to keep going up and up, okay? This is also going to impact our advice to clients in regards to payer compliance. Because remember, we have to start paying workers' compensation even when they don't have medical. And our advice in the past has been, well, to stay in compliance with the payer compliance law, we recommend that for the first 30 days, you make a payment at the minimum rate. Well, the minimum rate used to be $150 a week. So it'd be like 600 bucks of kind of a gamble. But now when the minimum rate is more than double that, that's going to be really a big challenge for employers. It's going to be a lot for them to swallow. So just be aware that that's coming. Lots of red flags when it comes to wages, and particularly the people that are in employments for a short period of time. Everybody knows my story. When I first started out in workers' compensation, the firm I worked for, one of our clients was a chain of exotic dancing facilities, okay, strip clubs. And one of the first cases I ever had to defend was a stripper who fell off a pole, literally on her first day of employment. Literally, she was paid by the dance, and literally the first song. And the issue was, what was her average weekly wage, right? And it's a challenge, and these things emerge, right? What did we do? Well, we took a similar employee and used their wages. My advice in our position is always, let's try to be as fair as we can. We're not, again, trying to game this for the lowest possible wage or allow them to get away with gaming the system for a higher wage. We want to be fair on wage. All right, last little part to talk about. My job, your job, is to create an unfair advantage for employers in this terribly tilted system. At best, this system's indifferent to employers. I feel like the state of New York hates employers. Everything they do, every law makes it harder to do business in New York. It's an awful state. But just like California, I think the position of New York's leadership is kind of like, we have 20 million people that live here. You want to do business in our state? Ha ha, we get to have this terrible, onerous, draconian workers' compensation system that's going to basically screw you every chance it gets. So our job is to try to get these employers a fair shake in a system in which every presumption is against them, every political bias in the system is against them. We're trying to get them a fair shake. How can we help them do that, right? And can we do it right at the beginning of the case? And what can we do? So my partner Christian came up with this hashtag, which is blown up social media. Has it? Not really. I don't know. Is that we don't say blown up anymore? It's lit. What do the kids say today? I don't know. All right. Hashtag DFD1. Okay. Use that everywhere. It's going to blow up now that you guys are paying attention to it. Defend from day one. Okay. So how can we create an advantage from day one? What can we do before the loss? What can we do after the loss? What are the creative things we can do? Because I don't pay you to bill hours. I don't give a shit about billing hours. I want to come up with creative things that we can do to help move these cases. Okay, so let's be thinking right from the beginning of the case, from the foundations of the case. It's not our job. We're not just task rabbits. We're not just moving cases. We're trying to come up with better ways to defend employers. So what can we do? All right, before the loss. All right, and my partner Tashia has written a lot about this, putting together and educating the claims team and the risk professionals and the responders to accidents to do a better job before the loss so that we're ready. Making sure that the people who take the initial incident reports are taking complete reports. The best initial incident report is written by the claimant themselves. If they don't speak English, I don't care, write it in their own language, right? Because that's, and as early as we can get that report, that is what we want. I fell down, I hit my head, my shoulder also hurts, I have a cut on my elbow. Cool, write that down. Because 5 years from now, when they're saying, I have a closed head injury and I've got the blues and now I have anxiety and all these other things that are going to come into these cases, when we can go back and say, well, here's the writing in your own handwriting, how the accident happened. You never mentioned your left ankle, your low back, all these other things, right? So right at the very beginning, can we get that stuff? Another thing our employers can do, particularly big employers with fixed locations, can we go to the local urgent care, the place where we know is going to be the first stop for our employees? Let's go talk to those physicians. A lot of these urgent cares, they're all fighting for business. Somebody noticed that how many city MDs have opened up all over the place? They're fighting for business. And if I had a big production facility or a warehouse, I would go to the local city MD and I would sit down with the doctors there and say, look, when one of my employees comes to you and says they got hurt at work, or we bring them to you, right? We're going to take them to you. We want you to fill out a really good intake form. And there's going to be a little picture of a body on there. And I want you to make sure they initial every place on that body that they say they got hurt, right? So that we can start to capture at the very beginning. And you can do that stuff. That's not undue influence, okay? That's not wrong. That's absolutely acceptable thing for employers to do. So that's some out of the box ideas or things they can do. Next, we need some cooperation, right? We have to work with these employers. Please, they've got to report these injuries. Every injury that requires more than first aid, and that means care rendered on site, or involves more than 1 day of lost time, has to be reported to the workers' comp carrier. Okay, so many of these things go, oh, it was a minor thing. You didn't report it to anybody. We didn't feel like telling the carrier about it. And 2 years later, I'm defending, I hurt everything everywhere. And Dr. Marola has already fused 5 levels of their back, right? It's too late at that point, okay? So getting them to do that. Preserving surveillance video. How many of every single one of our employers that we work with pretty much has surveillance or loss prevention cameras. Keep the video, don't lose it, please. Coordinating with the local business unit. Now, I know there are rules. Our rule here is we don't communicate with a location or a business unit until we talk with our risk professional and they okay it, right? Training and rehearsing the claims team. So many people maybe wouldn't file workers' comp cases if right in the beginning communication was better, or they felt cared for by their employer. They wouldn't get to us. We wouldn't have to litigate these cases. And we could just hang out and just enjoy Third Fridays and not have any cases at all. Like that would be an amazing outcome for us. I've seen employers go to extreme lengths. One of our clients, which is a giant parking enterprise, billion-dollar company, the risk director, Peter, hand writes get well cards to every injured worker every month to help them feel connected and related, because there's so much psychosocial tension that he's trying to alleviate and trying to make them feel connected to the workplace so they don't sue them, right? It makes sense. It doesn't probably cost a lot of money. How about collecting information about the petitioner early? And that does not mean hiring surveillance agents. Okay, the 2 things that we're always recommending, let's get an IME. That's not useful sometimes. Let's put them under surveillance. Well, do we need to? Like, what do we know about this person from the location? The best cases where I've gotten, by the way, the best surveillance is usually because someone else in the employment came forward and goes, hey, you know this guy? He actually is competing in the World Series of Poker, and he's going to be in Atlantic City in the next 2 weeks. That's great information, right? So what can we get from co-employees, co-workers? What kind of information we get? How about their job application? Right? Everybody who works here, I interviewed you or John interviewed you, or we all lied on our resumes, right? Right? We all pad it up and put things on there and you write down your hobbies and your interests. Like, that's good. Well, that's good information. I'd love to have it on some of our claimants, okay? Basic stuff. Would they come back to the employment? Now let's surveil them there. Right? That's going to help you in your scheduled loss of use cases, primarily going to help you in those cases. If we're providing transport, or if transport's an issue, like I think our clients should be more aggressive. Here's an idea. There's nothing that says that if we're providing them medical transportation to and from appointments, that we can't record them in the car, that we can't videotape them in the car. I mean, that's a great opportunity. I think it's kind of like a wasted opportunity. If we're transporting them back and forth, and again, in a high exposure case, why wouldn't we do this? And record it. See what do we get from this. See what they're actually, how they're actually presenting outside of the doctor's office. If investigators are retained, I love social media investigations, although Google seems to be doing just as good. I'm defending a case in New Jersey. This guy moved down to North Carolina. It's been such a problem getting him to medical appointments, and we've been bending over backwards. His attorney just filed a motion. And we Googled him, and guess what? I think he's serving time right now for larceny. He's in jail. That's why he's not going to his medical appointments. I Googled him. I mean, that's like the easiest thing in the world, right? Last thing is, I love covert surveillance. I love covert surveillance. I love covert surveillance. We should be doing it more and more effectively. A couple tips for covert surveillance. Please, let's get them inside the doctor's offices. That's a great place to catch them. Also, second tip, female investigators. Ask your clients, ask your investigation companies that you're using, please put female investigators on them. I'm seeing a trend of better results. I think people are less guarded or maybe less suspicious of a woman. Also, maybe it's easier for them to carry around cameras and bags and things. So female investigators, I've been seeing recently a trend of better results from. So that's one thing I would say. Expert selection, another unfair advantage. Okay, some stuff we can do that's kind of fantastic. We know in this jurisdiction, IMEs are problematic. Okay, you can't control them, can't direct them. In a heavy exposure case, consider a record review before you do an IME. You can get a bunch of record reviews done. If you like the record review, you can use it, right? You can disclose it to the other side. You can also disclose it to your IME doctor. So there's no problem with getting 2 or 3 of them, cherry picking the one you like, and then relying on that one, and you're only giving that one to your physician. You never have to disclose a record review if you're not going to be relying on it in court. So it gives you some latitude. I don't see us using enough record reviews. It's always go to the IME. Guys, I am 2025 IMEs. They didn't work in 2024. Okay, so let's take all of our eggs out of that basket and try some other things. Okay, record review is one of those things. The other thing, does everyone know that if we don't pick an IME doctor, the judge can, right? The judge is allowed to appoint an impartial, okay? That's a great place to go to look for maybe a different IME doctor, or you could also do record reviews to disqualify potential impartials. So if you have a heavy exposure case, and particularly a complex etiology case, being strategic about record reviews to disqualify the other side's doctors, that's a wonderful approach that I would love to talk to you about. Last 2 things. Prior claims history is key. I love ISOs. You can never get enough ISO information on people. But here's the thing I think we're not doing enough. 6 months after the case has been referred to us, let's get another ISO. And then 6 months after that, let's get another one. Because these people are accident prone, right? They keep having these accidents and stuff is going to come up. So think about getting multiple ISOs as your case develops. Last thing, comment, functional capacity evaluations. Very costly and only useful in a high exposure case, but I love them. Now, we can't, it's illegal, okay? There's a Supreme Court case on it. We can't put the claimant on a lie detector test. I would love to do that. Right? Like, okay, you have a claim against us, sit down, we're gonna take a polygraph. Right? Wouldn't that be cool? You're giggling, but like, why couldn't we do that? I'm gonna try. Okay, so the Supreme Court said can't do that. Okay, but a very well done functional capacity evaluation is basically a lie detector test. They will do things like distraction testing, Waddell testing. They will tell the person, hey, we're going to test your work capacity, so we're going to ask you to turn this wheel because that's going to simulate your job of driving a car. And they will tell the person, well, they're not actually testing how well you can turn the wheel, they're actually testing your grip strength with sensors embedded in that wheel. And they'll go even further and they'll embed sensors so they can tell the person's heart rate, or they'll have them wear a heart rate monitor so they can tell if they're actually giving an actual work effort, right? Because when they go to the IME doctor, and they tell you, oh, everything hurts, it's so painful. I'm in so much pain. Well, your heart rate's not elevated, you're not sweating, you're not really trying. It's all subjective. It is. Functional capacity evaluations are not as subjective. They are more objective. They take more time. They are more costly. But in a high exposure case, we should be obtaining them. There's another advantage to them. If you have them conducted correctly and they're useful, we don't have to pay for the other side to get their own functional capacity evaluation. So that means you'll be walking into your high exposure case, your multiple level fusion case, your bilateral hip replacement case, with a piece of objective scientific evidence that the other side doesn't have a contraposition to, right? They don't have contradictory evidence. And we don't have to pay for them to get it. And these things are costly. A good functional capacity evaluation will take between 4 and 8 hours to complete and will cost between $10,000 and $12,000. Okay, those are the good ones. Videotaped ones, run by a physiatrist or a biomechanical expert, usually a doctor in biomedicine. Excellent use, and use them in high exposure cases. So if you have a case with an OX 55, 65, 75%, and the person's average weekly wage is over $1,000, this is a good standard of care right here. Like, this is something that you can do. You can get a piece of information, and then you get that functional capacity evaluation, and then you give it to your IME doctor to make their opinion on. Well, now they have something in their arsenal that they can make an objective, credible determination on that's going to be useful, and your other side is not going to have any idea how to cross-examine it. In fact, I don't even think the rules allow for them to cross-examine our functional capacity evaluation expert. In all my years of getting these things, I've never had anyone cross-examine. I don't think they know what to do about it. So that's another idea or something we can do. So again, when you're thinking about the beginning of the case, like, this is the time for us to be giving our client an advantage that maybe they wouldn't have if we did nothing. Practical takeaways, let's be decisive. our job. If we have a denied case, let's get it sustained. That's a win to me. We can always withdraw denials, right? So my opinion is let's over deny. Something like 30% of the cases that are coming in, we give denial advice in. Occupationals can be defended. It takes a little bit of effort, but that's why we have discovery opportunities. Please, let's fight on the wages. Let's argue for straight division. I know the judges are going to give you pushback, but that's our job, is to advocate. Last thing, defend from day one mentality. Even from the beginning of the case, even something minor can be useful in helping you defend a case later. Okay, that's it for today. Thank you for joining me. If you like this, I recommend strongly my partner's podcast. It's excellent. All right. Thank you.